Good morning again, everyone. We're ready for session number 6 of our virtual commodity conference. I thank you all for joining us. Format is different than we used before, as obviously we're having separate sessions. This one will end at 10 and we'll begin the next one immediately after, but you will have to log out and log back on if you're using Zoom. Obviously not a problem if you're on Facebook Live. You can ask a question anytime during the presentation by typing into the question and answer session on Zoom. If you're on a conference call or if you're on the phone, please push *9 and we'll get to your question wherever it is in the queue. Our speaker this morning is Zell Fisher. He was an associate judge at the Supreme Court of Missouri. He was appointed to the Supreme Court in October 2008, retained in 2010 election for a 12-year term expiring in 2022. Prior to becoming a judge of the Supreme Court, Zell was a trial judge, trial lawyer in Northwest Missouri, where he was born and raised and still resides today. More about that later. He's a frequent lecturer to judges and lawyers regarding the intersection of science and the law, as well as constitutional issues and professional ethics, and is also actively involved in presenting constitutional forums at high schools, colleges, universities, where he impresses upon the students the prominent importance of promoting the rights guaranteed by the Constitution. Zell and I share a grandson. His daughter's married to my son. And the other thing we share is a great deal of gratitude that Levi, our grandson, looks like his grandmother's. And you can see how important that is as you look at me and as you see our next speaker, Zell Fisher.
Well, thank you. I'm honored to be here with you today, and we're going to give you a little overview on your court system. The title is Court System 101. We're going to talk a little bit about the federal system and the state system and how they work together. If you do have a question about the federal system, I'll try to take a little pause after I deal with that to deal with that, or I can deal with questions at the end. The framers of our Constitution provided that the Constitution itself created the Supreme Court of the United States and said such inferior courts as Congress may provide. And the screen that's on the slide that's on the screen right now shows you a diagram of our current federal system. And it's been this way for quite some time. The country is divided into 13 federal circuits. When we talk about the federal system, circuits are courts of appeal. You'll find that when we talk about circuits, when we get to the state court, that's our trial courts. But the federal circuit has 13 circuits, and we have 94 district courts. In the federal system, your trial courts are known as district courts. But in any event, our framers only created one court, the Supreme Court of the United States, and such inferior courts as Congress will provide. Now, we all know that our federal government was intended to be a limited government. And so federal courts have limited powers. The slide that you're looking at right now just gives you an instant overview of how the Supreme Court of the United States comes to hear its cases. And we can talk more about that later. But if you look at the left side of that slide, you see there are these trial courts where everything starts, and then it goes up to the federal district courts, and then eventually, very few cases by right to direct appeal to the Supreme Court of the United States. They have a lot, most of their cases are discretionary, and so they get to pick a lot of the types of cases that they hear, although there is a direct appeal jurisdiction to the federal courts. Each circuit has several appellate judges, but they sit in 3-judge panels. District courts, they hear the case one-on-one, and then all for really since almost the beginning of time, our Supreme Court of the United States always hears their cases en banc. When we talk about the Supreme Court of Missouri, you'll see that we hear our cases en banc too. That means all of us sit at the same time. But courts of appeals often, whether in state court or in federal court, sit in panels of 3. You see that the Supreme Court of the United States can take cases that come through the federal courts or through the state courts. The only way that a case would not have the ability to go all the way to the Supreme Court, as somebody might say if they're angry about what happened at the trial court level, is that if the state Supreme Court decides an issue on an independent and adequate state ground, even if there's a juicy federal issue involved in the case, the Supreme Court of the United States has pretty consistently stayed out of and not taken cases from state Supreme Courts if they've decided it on an independent and adequate state grounds. For years, state Supreme Court justices paid no attention to that in the sense that they just decided their cases without regard to whether or not they would be appealed or not. But I've noticed in the last 5 to 10 years, state Supreme Courts often look for an independent and adequate reason to decide their cases in addition to the federal question. And I think some of that is purposely done to avoid further federal review. Now, I've been wrong a lot in my life, so it doesn't bother me. In fact, I'm happy to have them review my paperwork anytime. But you do see some state Supreme Courts looking for independent and adequate grounds to decide some of their cases. So the federal court has some specialty courts that you might have heard of. And oftentimes the judges in these courts are specialists. So you got your tax court, your military court, United States Courts of Veterans Appeals, all those are specialty courts. So income tax cases, federal income tax cases, military discipline, things like that are always heard in the federal courts. And then of course, all bankruptcies are heard in the federal court because they're created by federal statute. But there are two primary ways that cases get or start in the federal court. They either involve what's called a federal question, which means the issue involved or the cause of action that's created comes directly from the Constitution of the United States or from a federal statute. So if not that state courts can't hear those, oftentimes they can, there's dual jurisdiction, but you can always file in federal court if there's a federal question involved. The other way is, of course, if the United States government is a party. So some of you might be familiar with the flood litigation that's occurred throughout the Midwest against whenever the United States is a party, the case is heard in federal court. The other way that the federal courts get a lot of their cases, and keep in mind, the last statistics I saw were that the federal courts only hear about 5% of our cases. 95% of the legal questions and cases are resolved in our state courts. But the other way that the federal courts get a lot of their cases is called diversity of jurisdiction. And it generally involves when there's a citizen in one state has a lawsuit against a citizen of another state. And so, surprise, surprise, back when all these statutes were created, there was some thought that the state courts of one state might not be fair to the citizen of another state. Now that seems kind of foreign to me, but if you're familiar with the Tiger-Jayhawk rivalry, you can see how that might come into play. And so we've always provided a mechanism that if you were suing somebody from another state or getting sued, there was a way to deal with that by the federal court. So that might mean, if that exists, that you could file the case to begin with in federal court. And that might also, there's a thing called removal. If you were sued by somebody from another state, you could remove your case to federal court. So it's kind of a release valve if somebody might think that they can't get a fair shake in their state courts. Now, interestingly enough, that diversity of jurisdiction has a monetary threshold. So this statute's been on the books when $75,000 was oodles, gobs, and bunches of money, but that's never changed. So Congress has never, they could easily do that. Congress could raise that amount to be $500,000 or $1 million. And in today's dollars, that might actually be more realistic as to what it set out. But Congress has left in place this idea of diversity jurisdiction. The federal question, again, we talked about that briefly. That's anything, any cause of action that would arise out of the United States Constitution or a federal statute. So there are some federal crimes, although most crimes are dealt with in the state courts. Bank robbery, for example, has always been a federal crime. Most of the federal crimes relate to interstate commerce and have some dealing with interstate commerce. So kidnapping that starts in Missouri or ends up in Kansas, or starts in Illinois and ends up in Missouri. Those have traditionally been federal crimes because the authority of a state court judge pretty much ends at the state line. So there have always been a small number, at least, of federal crimes and also federal civil actions, primarily dealing with interstate commerce. To give you another example, suits between states are always heard in federal courts. There was an issue sometimes with state boundaries. It doesn't happen as often now, but the Missouri River, for example, the Mississippi River changes channel from time to time. And so if states would get into litigation about what belongs to who, that would be in federal court. In Missouri, there's a place up in Northwest Missouri called McKissick's Island, that there was a dispute between Missouri and Nebraska regarding the state boundary when the water changed. And then years later, so the Supreme Court of the United States actually drew the legal description of McKissick's Island. And years later, we had a boundary commission where we decided to kind of give them everything on their side of the river, and Nebraska decided to give us everything on our side of the river. But McKissick's Island could not be given away because that, for example, that legal description was drawn by the Supreme Court of the United States in a federal question case. So just a little bit of Northwest Missouri trivia. We'll question you about that at the end of the presentation. Okay. Again, this is the diversity of jurisdiction that I talked about, the other way that federal courts get cases. Again, the key there is that the damages have to be in excess of $75,000. There's some other examples of federal questions are admiralty law. If you received a traffic ticket in Yellowstone, for example, that's on federal land, that would be a federal case. But pretty much all federal jurisdiction is limited to those cases that arise out of federal statutes, the Constitution, or lawsuits between citizens of different states. In my view, no presentation of the legal system is really complete without some discussion about judicial appointments and how that occurs. When the framers of our Constitution were putting together how to select judges and how the federal system should operate, one of the things that they thought was a hallmark of judicial independence, in other words, that the judge could always do what the judge thought was right to do under the facts and law, was lifetime tenure. And so if you're appointed to the federal bench, whether it's at the district court, the circuit court of appeals, the Supreme Court of the United States, you have lifetime tenure. I don't think it was anticipated that judges would try to live out their terms when they picked this as an item of judicial independence, but it was to ensure that there wouldn't be retribution, political retribution, based upon the decision of one case. But the way that you would get appointed as a federal judge requires appointment by the President of the United States. That's for every trial judge all the way up to the Supreme Court of the United States, generally nominated by the senators in the home state where the judicial position is open, and then subject to Senate confirmation. We've seen recently that Senate confirmation process is highly politicized. And I think that's as a result of the fact that when you're appointed a federal judge, you serve for a life term. An interesting, and then I'll try to remember to talk about this when I talk about the Missouri Supreme Court, but there seems to be a lot of weight that pundits put on who's the author of these opinions at the Supreme Court. I think that too much weight is given to that. So just so that you know how that's chosen, the Chief Justice of the United States Supreme Court gets to pick who authors the decisions in that court. If the Chief Justice is not in the majority, then the most senior justice in the majority gets to decide who writes the opinion. So I think a lot of lay people put too much significance on who the author is, but in case you wondered, that is how it gets decided. Now, does anybody have any questions about federal court? What types of cases they hear? What by jurisdiction? That's just another way to think about the power of the types of cases that they hear. Again, the federal courts get all the press, but us lowly state Supreme Court judges do most of the work. They hear about 5% of the cases. We hear 95% of the cases. You also primarily hear about the cases where there's huge divergence in opinion, 5-4 splits and so forth. Even the Supreme Court of the United States have a significant number of their cases that are unanimous, probably at least 65% of their cases. And most of those will be in regard to those cases that you have a direct appeal. Before we go on, I'll give a little talk about how the Supreme Court of the United States decides to hear their cases. There's a doctrine called the writ of certiorari. So the Supreme Court of the United States, again, doesn't have to hear a lot of cases, and monthly they receive petitions from lawyers who are unsuccessful at state Supreme Courts or who are unsuccessful at federal circuits, asking them to take their case. And what they try to do is convince the judges of the United States Supreme Court that their case is generally interesting and important to the entire nation, or that there's a split between the circuits of the United States. And I think that certainly when there's a true circuit split, and there oftentimes is on close questions, that the Supreme Court of the United States ought to grant certiorari on those cases. They seem to do it slower than I think that they should, because the law ought to be the same, whether you're in the First Circuit, the Eighth Circuit, the Ninth Circuit, and so on. And when we get to talk about the Supreme Court of Missouri, I'll tell you how we deal with that. But the Supreme Court of the United States is a lot more strategic about the cases that they do decide to take. They seem to let differences between the circuits percolate a lot more than we would do here in the Missouri Supreme Court. Did you have a question, Blake? Okay. Yeah, so federal claims court, how many takings cases? I don't know by numbers, but there's a lot more takings cases than historically. Because there are different, there are more creative avenues to try to plead a takings case in the federal courts than there once was. Previously, it was fairly limited to more like eminent domain and topics like that. Although eminent domain is a very hot topic in state Supreme Courts. And in Missouri, within the last 4 or 5 years, we had a case that percolated up to us, not on a constitutional basis, but on a state statute, which waded into the issue about whether or not commercial development is an appropriate use of the condemnation, government powers of condemnation. Okay, well, I will move on into the state court system. Again, this is where all the most of the cases are heard. State courts are not of limited jurisdiction. They are of general jurisdiction. So state courts hear the same types of cases in federal court. You could file it in state court, dual jurisdiction, but they also hear everything else. So everything from every civil case, every criminal case, almost all of those cases can begin in state courts. Every time the legislature passes a new statute, lots of times new causes of action are created. Our state legislature also has the ability to remove causes of action. So in addition to statutory causes of action, we have traditional common law causes of action that our American courts have inherited from the European countries for where we have some of our heritage. The state courts have fewer specialty courts. The slide that you're looking at now talks about some of the state courts. We have treatment courts, DWI courts, drug courts, juvenile courts, veterans courts. So over the course of time, society and our citizens, which is really the court's constituencies, have started looking to the courts not just to resolve disputes, but deal with social problems such as addiction or some of the mental health issues that come with some of our veterans and alcohol and drug abuse. Traditionally, things like that, if somebody became incompetent, would have been dealt with in our probate courts through guardianships or so forth. But in response to really citizens asking us to create problem-solving courts as opposed to just resolving cases, we have developed some specialty courts that deal with mental health, veterans issues, drug issues, alcohol abuse issues. They aren't really specialty courts in the sense of jurisdiction like the federal specialty courts where all tax cases have a certain track. These are really divisions of our circuit courts. So our circuit courts have created special divisions. Oftentimes they have judges who have special training to deal with issues that might frequently show up in veterans courts or drug courts. Let's see the next slide. So circuit courts are our trial courts in the state system. If you look at the slide that's there in front of you, you see that our state is divided up, much like the country was divided up, into circuits. We have 45 circuits in the state of Missouri. Some of our circuits are just one county, if you look at the metropolitan areas. So for example, Jackson County is its own circuit, Platte County is its own circuit, Clay County is its own circuit. The city of St. Louis is its own circuit, St. Louis County, Greene County. And so our metropolitan areas have enough court business, if you will, that it might be its own circuit. And then if you go to the more rural areas, like up in Northwest Missouri, where Blake and I live, our circuit is made up of 5 counties. So anyway, we have 45 circuits across the state. Of the 115 counties, every county in the city of St. Louis has at least one courthouse. And we think that's important from an access of justice issue. Also, our Constitution currently provides that at least each county has at least one associate circuit judge. And again, I think that's important from an access to justice issue. Whether you're in the metropolitan area or in a rural area, some judge is on duty 24/7 to issue a search warrant, to issue an order of protection if there's a domestic violence issue. So court's always open. There's always a judge wherever you live that's always on duty. And in the rural areas, each county has at least one associate circuit judge. And if that judge would happen to be on vacation or training or assigned somewhere else in the state, there's another nearby judge who's assigned to take his calls or her calls and perform those judicial functions. You have no constitutional right to appeal in state or federal court. Those are all created by statute. In Missouri, we have 3 courts of appeals. We really have 1 court of appeals, but it sits in 3 different districts. One thing that's different about our courts of appeals and our Supreme Court is they can really hear cases anywhere. Similar to the federal system, although there are numerous judges on our courts of appeals, they sit in panels of 3 primarily. The Western District Court of Appeals, which Jefferson City here, Cole County, primarily sits in Kansas City. There are 11 judges in our Western District Court of Appeals, again, that sits in panels of 3. They sometimes hear their cases out remote at universities, high schools, and so forth for civic education. The Southern District, which is almost the entire southern half of Missouri, sits primarily in Springfield. That's where their main courthouse is, although they hear some cases at least once a year in Poplar Bluff in the southeast Missouri, and again at universities and high schools. And there's 7 judges on the Southern District Court of Appeals. The Eastern District Court of Appeals sits primarily in St. Louis. There are 14 judges that comprise the Eastern District Court of Appeals. The old federal building over there is where their court is primarily housed, but again, they hear cases in Cape Girardeau, hear cases up in Hannibal, and travel some to universities. For most people, if you're dissatisfied with your case, however it started at the circuit court level or the associate circuit court level, or for that matter, the municipal court, which we have many of those in the state of Missouri, your direct appeal would be to the Court of Appeals. And for most cases, that's your last direct appeal of right. In other words, you could say, I'm going to take my case all the way to the Missouri Supreme Court, but it doesn't really work that way. For most of you, your right of appeal, the direct appeal, is to the Court of Appeals. We do have some discretionary jurisdiction at the Supreme Court of Missouri. If you're dissatisfied with your decision at the Court of Appeals, you can file what's called an application for transfer, and that's the state equivalent of that writ of certiorari that we talked about with the Supreme Court of the United States. And again, the rules are almost the same. If you can convince 4 of us that your case is generally interesting and important to the entire state, or that the courts of appeals in different districts are in conflict, then we can decide to take your case. There's another discretionary jurisdiction called extraordinary writs, which deal if you think the trial judge is acting in excess of their jurisdiction or abusing their discretion, you can apply directly to us. We'll get about 60 of those requests a month, either for application of transfer or writ for our discretionary jurisdiction, and we'll sustain about 6 of those. So 6 out of 60 of those things that we have our discretion whether to hear or not, that we will take. The other way that you get to the Missouri Supreme Court is there's some categories where you can bypass the Court of Appeals and go directly to the Supreme Court. So when the framers of our state constitution were developing this appellate jurisdiction, there's some things that they thought were so important that you could bypass the Court of Appeals and go straight to the Missouri Supreme Court. And that involves constitutional challenges to state or federal statutes, the appeals of all death penalty cases, right? The writ of quo warranto, which has to do with malfeasance in office, if a statewide public official thought that there was some sort of malfeasance. And taxes. So surprise, surprise, way back when we framed our Constitution, the framers thought that if you wanted to appeal a tax case, they're so important, you ought not to have to go to the Court of Appeals first. And so not so many years ago, we had a relatively small, in the sense of dollars, like I think it was less than $100, a sales tax issue that came all the way directly to the Supreme Court of the United States, or no, Supreme Court of the state of Missouri. Thank goodness the Supreme Court of the United States did not grant cert on that case. And you might wonder how somebody could afford to take a sales tax case that was worth less than $100 to the Missouri Supreme Court. And it might not surprise you that one of the litigants was a lawyer, and it was very personal to him, the issue involved. And so he took it to us, and although there were several county commissioners that were surprised by the result, it was certainly unanimous at our court, and it was just one of those things that had gone unchallenged for quite some time, but was a fairly easy question to answer once you put pen to paper and read the statute. So anyway, my work is very interesting at the Supreme Court because there is a large section of the cases that we hear that are either constitutional challenges to state or federal statutes, the death penalty cases, or cases that are generally interesting, important to the entire state, or that there's a conflict between the states. One thing that I forgot to mention when we were talking about the Supreme Court of the United States is for their discretionary jurisdiction, There's 9 of them. There's 7 of us. In order to grant cert, it only takes 4 judges from the Supreme Court of the United States to make them hear a case. So a minority of the Supreme Court judges can make the majority hear a case. The rules are at the Supreme Court of Missouri and most state Supreme Courts is that a majority of the judges must have to think that it's generally interesting or important. So 4 of us decide our discretionary cases. In other words, you'd have to convince 4 of us that your case is generally interesting or important in order for us to decide it. So I told you how the Supreme Court decides who writes their opinions. The Chief Justice does that, or the most senior justice in the majority. My first tour of duty at the Missouri Supreme Court was way back in 1988 when I was a law clerk. Each judge gets 2 young lawyers to work for them. And this tradition goes back as far as that in any event, and I think some distance farther. We have a work equalization method. You get every 7th case that comes along, and if you're in the majority, you would be the author of that case. If you're not in the majority, whoever the next judge is in line would write the case. So we don't pick the order of our cases. Our clerks and so forth, along with our legal counsel, set the order of our cases. But so we're very, I think, civilized. We have a work equalization method. Every 7th case, as long as you're in the majority, you write it. If you're not, they'll skip and you get the next case. So that's how authorship is decided at the Supreme Court of the United States, or the Supreme Court of Missouri. Okay, let's see the next slide. So to give you some examples of the types of cases that we hear in state court, all of the state crimes, family law issues, adoptions, divorces, all real property disputes, landlord-tenant actions, malpractice cases, whether that's medical malpractice, legal malpractice, personal injury lawsuits, so all types of torts, whether that's negligence or intentional torts. Really anything that you could think of that doesn't involve a federal question or diversity jurisdiction is heard in the federal courts. Everything from first-degree murder down to speeding tickets. So it's a wide array and a variety of cases. Let's see what the next slide brings us. Okay. Oh, selection of Missouri State Court judges. Back in 1940, we adopted a constitutional amendment, which was at that time the first in the nation. Missouri developed a nonpartisan judicial selection method that applies to all of our courts of appeals and our trial judges and our metropolitan circuits. In the rural areas, judges in Missouri run on a partisan ticket, Republican or Democrat or independent, just like your other public officials. But the idea was to take partisan money and money out of the politics of the judicial selection process. And at the time, there was also some organized crime issues in the state of Missouri that they wanted to take some of the crime bosses out of the selection of the trial judges in the metropolitan areas. So in Missouri, at the appellate level, there's a commission. The Chief Justice of Missouri, which we rotate every 2 years, chairs the commission, but there are 3 lay people, one from the Southern District Court of Appeals, one from the Western District Court of Appeals, one from the Eastern District, that's appointed by the governor, and they serve 6-year terms. So somebody who's not a lawyer from each of the appellate districts on a rotating term. And then there are 3 lawyers, one from the Eastern District, one from the Western District, and one from the Southern District that are elected by the lawyers. So the Missouri Bar elects a lawyer that from each of those districts. And all of those positions rotate. There's somebody on that commission that's coming on and somebody who's coming off almost every year, including the Chief Justice. That group gets together and interviews the applicants. So for example, in 2008, when I applied to be a judge of the Missouri Supreme Court, there were 23 applicants. That being so few people who applied, and has continued to be the tradition, that commission interviewed every one of us. And then they give what they perceive to be the top 3 candidates to the governor. And the governor then has 60 days to review the application, their credentials, and take input from the public. And then the governor appoints within that 60-day period. If the governor would fail to appoint, and no governor has failed to do that, then the commission itself would get to select the judge for the Court of Appeals. Again, the people then have another say, because once you've served a full year, the next general election after you've served a full year, you're put on the ballot. So if you're a Western District Court of Appeals judge, every county in the Western District votes whether or not to retain you. I'm from Watson, Missouri, population 100 from Atchison County. Most of you've never heard of me. So within a couple years of being put on the Supreme Court, I ran statewide. And your choice was, shall we retain the Honorable Zell Fisher, yes or no? And there's a couple different publications that put out information concerning my credentials. I have to submit opinions that I've written to these folks, and they review it and they give some sort of recommendation. You also have the ability to listen to me every time we have live oral arguments. They're broadcast live on the internet. They're also archived. And you can read my opinions, which are all published. The governor and the legislative branch oftentimes get all of their information from whatever source, and their decision until they make it is not public. And once they do, of course, it's public, and they can explain to you why they made their decision. But we judges, we have to do more than just that. We have to show you our work. We have to show you our math. So every Supreme Court decision comes with a written opinion that explains the legal analysis for which we have made our decision. So again, the judges in the metropolitan areas, Jackson, Clay, Platte, St. Louis City, St. Louis County, and Greene County pick their judges nonpartisan selection plan. Counties can decide whether or not they want that system or partisan elections. The only county that's recently switched is Greene County. And within the last 5 or 6 years, they've chosen the nonpartisan judicial selection method. And trial judges, associate circuits serve 4-year terms, circuits are 6-year terms, Court of Appeals and Supreme Court are 12-year terms. So I last ran in 2010, and so I'll be up for retention in 2022. All judges in Missouri are mandatory retirement at age 70. So does anybody have any questions for me? Do we have any written questions coming in? Okay.
Well, I have one. How often are judges denied? When you at the end of 12 years, Supreme Court justices stand for reappointment or confirmation, I guess you'd say. How often do we vote no? Does it never happen?
So since 1940, we have never had a Supreme Court judge or Court of Appeals judge not get retained. Interestingly enough, you're not allowed to campaign unless you get organized opposition. So on the few occasions where a judge has received organized opposition, then they're allowed to campaign. So there have been some races that are close to another. We certainly have had trial judges in the metropolitan areas who have lost retention elections. It doesn't happen as often as partisan elections, but it has happened in our trial courts. It's never happened at the Court of Appeals or the Supreme Court level, and very rarely has there been organized opposition. So when I ran for, and I've run both, like I've run as a rural judge in Atchison County. I ran against a 3-time elected Democrat prosecuting attorney, spent less than $500 back then in my election in Atchison County, received 71% of the vote. When I ran statewide 2 years later with no opposition, I think I had 63 or 64% retention. So it's a little unnerving to run statewide and not be able to campaign, especially if your name is Zell and they're trying to figure out where you're from. And the best you can do is say Watson, Missouri. But anyway, it's an interesting process. I do think on the rare occasions when there have been organized opposition that you see something closer to a traditional campaign, but it's been extremely rare. Now, those of us who are listening to this call who live closer to the Illinois border and have TV outlets, you see what partisan elections for Supreme Court races are like. I think the last Illinois race for Supreme Court, there was around $10 million spent on each side of that. And so I'm not sure where that money comes from, but my guess is that it's out of the same pool that takes away from the other elections that are going on at the time. But I really don't know.
Stan wants to know, where do you get information on judges in order to make informed decisions?
So there's a commission that gets together before the elections, and they receive all sorts of information from the surveys of citizens and also lawyers, and then they give recommendations on whether or not to retain or not retain judges. I think the Missouri Bar, although it isn't the Missouri Bar that does it, they do publicize all that information. If you go to the Missouri Court's website, you can probably see what may still be up from last election, but there is an organization that's appointed that evaluates judges. So trial judges, as you might anticipate, are evaluated differently than appellate judges. There's jury surveys, citizen surveys, lawyer surveys that evaluate your trial judges. Appellate judges, we have to send in a written work, so we'll send opinions and so forth to this same committee or commission, and they review our decisions, both principal opinions, which when we were in the majority, or if we dissented or wrote a concurring opinion. Those are also evaluated. Now, one thing about that is it's interesting, if you're a trial judge, we actually rate you on whether you show up on time. Blake, and I think that's okay that you're rated on whether or not you show up on time, but I'm at the mercy of all my colleagues. We all 7 of us have to be there before we go on the bench, but all sorts of factors, politeness, courtesy, professionalism, all those things are in those evaluations, and you can see what the commission's considered.
Well, thank you, Zell, and thank you for being with us today. And we have to stay on time as well. So we're going to end this session. We'll restart the Zoom session at 10 o'clock. So if you're on Zoom, log out and immediately log back in. And we'll be joined by Henry Olson from the Washington Post talking about the upcoming elections at 10 a.m. We'll see you then. Thank you.
Thanks for having me. It's an honor to serve you.
All right. Great job.